The objective of this program, of course, basically is to provide the necessary knowledge inputs for those who wants to be data protection officers, DPOs, in the Indian scenario. See, GDPR has been in place for quite some time, and there have been DPOs already. But to be a DPO in India, when perhaps the new law is in place, I think the DPOs under GDPR also need to slightly relearn things in the Indian context. So we feel that this program will try to help people who want to be DPOs or people who are already in the organization in some capacity, looking after the privacy and looking forward to being promoted as DPOs, because DPO is a position which our law has recognized as something very close to the board. Okay. Then we have the class of people who are coming up called data auditors, and the Indian law has specially given a career path for, you can say, veteran DPOs who want to actually provide assistance to the industry in a different capacity. Now, in addition, this particular program, I have been insisting that those of you who want to be trainers yourselves in DPDPA should also look at this kind of a program, because say as DPDPA takes shape, we will be having one need for taking DPDPA knowledge to all over India. It is almost impossible for our team to actually take care of all these things. And many times people do prefer physical programs, which definitely is out of bounds for us in a number of places. So we felt that those of you who are not intending to be DPOs, but not intending to be data auditors, but are having the aptitude to learn and disseminate knowledge, they should also look at this as a program of training the trainers. Of course, each of these things require some additional requirements, but at least we want to keep this as our own objective. And this will provide a reasonable understanding of the challenges in implementation of DPDPA in an organization beyond acquiring the knowledge of the law, act, and the rules. Thirdly, we would like to provide insights to the framework for compliance, DGPSI, Data Governance and Protection Standard of India, which we consider as a good framework for implementation. And after implementation, if data auditors want to use it for audit, that also it is something which should be useful. So these are the objectives with which we have set aside our program this time. Okay. Now, obviously, for a DPO, our law says that he should be an individual responsible to the board. Now, in GDPR, we have heard of external DPOs, sometimes from the firms, whereas in India, we feel that the law now requires the person to be an employee. Now, when he is an employee, he also has to be located in India. So if in the case of MNCs, they cannot have one global DPO sitting somewhere who is also designated as a DPO. There has to be an India-based DPO. But when we say located in India, there are still questions to be asked. What does it mean to be located in India? Because today people keep traveling. And does it mean that the person should have a physical address in India, a residence in India, a rental agreement in his name, or a property in his name? Or is he to be paid out of Indian registered entity? That is, he should be a person who is in the PF roles of an Indian company. These are issues which will come up later on, because there will be occasions when questions will come up about the credentials required for a DPO. We today feel that he should be a person located in India, a fairly senior person, and he should be having a clear channel of communication to the board. We are in our DGPA side most of the time suggesting that there can be a governance body, we may call it as a Data Protection Governance Committee, where there could be an independent director as the chairperson. Therefore, it represents the board. So because in big companies, it is not always possible for the DPO to be directly reporting to the board. But today, company secretaries may be reporting directly to the board. So it is not something unseen or unheard of. But still, under DGPSA, we are trying to recommend that the companies can create a data governance committee, which should be chaired by a member of the board and ideally an independent director. Not all companies are still comfortable with this suggestion. We have been working with some big companies, but they have their own limitations. They can't make any changes at the board level, but you have a committee, and to have a representative of the board in that committee is essential in our reading of the act. Otherwise, the DPO, the designated DPO, where it is required, because in what we call as significant data fiduciary, it is mandatory to have a designated DPO, and he should be considered as the secretary of this governance committee, so that the purpose of directly being in communication with the board is served through this particular committee. And this particular data protection officer, the law says, should represent the data fiduciary. Because this is mandatory for significant data fiduciary, we can say that he will be responsible to the board and represent the data fiduciary or significant data fiduciary. What do we mean by representing is another question which we will be deliberating over a period of time. But essentially, to the outside world, the data protection officer is the person who is responsible for implementation of the PDPA. And the law also recognizes that he should be the point of contact for grievance redressal under the Act. We have heard of the term grievance redressal both here as well as in the Information Technology Act. And companies may think whether we need a different data protection, grievance officer under ITA 2000. In addition to the DPO, they can see if there is a requirement, they can do that. Otherwise, perhaps the DPO will anyway continue to be the person to whom all complaints from the data principles will be addressed. And later on, he will actually direct if a particular grievance has to be handled by a legal compliance team, he will direct it there, or to some other team, he will handle that distribution separately. But he will be the point of contact for data principles, and therefore his contact should be available in the on the website actually. Okay, if it is not available on the website, you cannot expect somebody to send a mail to find out who is your DPO. Now, if you actually browse through many of the websites of many of the companies, you don't easily see a contact person who is named as the DPO, as well as a grievance officer under ITA 2000. In fact, all companies today should be first ITA 2000 compliant, and then they should look at DPDPA compliant. So there should have been already a grievance officer in most of the companies. And now we also require a data protection officer in case they are handling personal data, and particularly if they come under the category of the significant data fiduciary. Now, as of now, the credentials have to be drawn from this general description. The knowledge of DPDPA is required. The ability to convert the legal knowledge into technical environment is required. He should also have the capability for, say, resolving disputes, guiding peers, and dealing with the regulatory agencies, which is all what a lawyer will normally be capable of doing. But the traditional lawyer will have to learn a lot of things about ITA 2000, about the technology, and the ability to deal with peers and superiors within the organization is a kind of an interpersonal skill they have to develop. Now, the question about the knowledge of GDPR, ISO 27001, etc., is all very much desirable, but it will not be sufficient. What we need to avoid is the complacency that I know everything about GDPR, I have been handling it for several years, therefore I don't need to learn much about DPDPA. If we avoid that complacency, then a current GDPR specialist will be very useful as a DPDPA specialist. But whenever we try to learn something new in the same area, sometimes it becomes difficult to unlearn the past. So psychologically, you have to be prepared to unlearn the past, drop the thought that GDPR is the gold standard, because you are actually now dealing with DPDPA. That if a person is capable of doing, then I think he will be the person who will be a good DPO. So there is a techno-legal knowledge required, interpersonal skills required, and also the dispute resolution skills required. In fact, FDPPA has been trying to organize, if possible, a mediation related certification program. I have not been able to successfully do it because I wanted the partnership of people who have greater legal knowledge on Indian Arbitration Act and Mediation Act. So that is remaining as one of the projects which I have not been able to take up. Now, if you come to the data auditors credentials or something like that, again, data auditors, it is mandatory for significant data fiduciaries, but the law is very clear that he should be an independent person. So the distinction between the DPO and data auditor is that in the case of data auditors, it is mandatory that he should be an independent person, whereas in the case of DPO, it is not mentioned independent, and there is a need to report to the board. So we are interpreting it as an employee. Today, there are many small companies where the company secretary is not an employee, but he could be an external person. So there are reasons for us to debate on what should small companies do, whether they should go for a full fledged DPO within their organization, or they can take an external DPO. What we are suggesting as a Via Media is for companies to designate a person who is an employee as a DPO and retain an external consultancy firm as a consultant to guide the DPO. In fact, to facilitate this, we have a corporate membership scheme in FDPPI, where a corporate member will get continued mentorship of FDPPI, and therefore that will serve the purpose of pulling the FDPPA experts whenever it is required. So some kind of a corporate membership and what we have currently planned is concessional services, even the retainer. So we are trying to help the SMEs who may not be able to afford a qualified data protection officer, and but still we are insisting that there should be an accountable person who is an employee of the organization. This data auditor, on the other hand, should be an independent person. So he has to be a non-employee. Now, whether he can be a firm or an individual, you can still debate. It uses the term person, but the term person also could be extended to an organization. So while the audit may be ultimately done by a human individual, he may belong to an audit firm. So probably that will be acceptable. Now, this person has to do annual audit. It is mandatory for significant data fiduciaries as per the draft rules also. And what he is supposed to do is a data compliance audit. This is not an audit similar to financial audits and other things. He has to do a DPDPA compliance audit. Additionally, data auditors can also be used for periodic data protection impact assessments whenever it is required, and any other periodic audit which an organization needs to undertake. Of course, the concurrent audit responsibility can also be handled by the DPO. Therefore, the knowledge and skills required by the DPO and data auditors overlap, and that is why we are having this particular program as a common program. Many people have asked, how can we have a common program for DPO and data auditors? Because ISO doesn't perhaps do that or something like that. You should have an implementation training separately from audit training. But I have felt that at this point of time, the essential requirement is that whether you are a DPO or a data auditor, you need to understand the law and its implementation intricacies first. Then, depending upon their own say capabilities, some of them will be happy to be independent data auditors. Now, otherwise, both need a in-depth knowledge, but an auditor normally is somebody who is inquisitive, is capable of asking the right questions, extracting the evidences, have a good documentation skill and observation skill. He should be able to empathize with not necessarily the companies, but with the data principles. The main objective of this DPDPA is to actually protect the privacy of the data principles. Though the Act nowhere mentions the word privacy, still, because there is a need for the organization to conduct its activities in order to minimize the harm to a data principle, we see that the privacy concept is embedded into the data protection law, except that it is limited to the digital personal data. So the data auditor, of course, even the data protection officer needs to empathize with the data principles. Okay, though the DPO gets his salary from the company, when it comes to the crunch, if there is a conflict of interest between the company and the data principal, he is expected to actually take the stand of side of the data principal. If it doesn't do it, then I don't know, there could be a sort of a breach of trust accusation which the data protection board may impose. If you remember, I think today there was a news that E&Y was imposed a fine of, I think, around 51 crores or something like that because of deficiencies in their audit responsibilities. And we have seen earlier PwC people have been imprisoned also in certain cases. So auditors have been expected to bear certain responsibilities beyond the technical duties of just checking certain provisions. So I think today DPOs may not expect that Indian law will be strict. Of course, in GDPR, it is clearly mentioned that the DPO is a person who should be considered independent. The company should not take adverse action against him for his duties, and he will be protected or something like that. Indian law doesn't make specific recommendations on such things. But in a future court decision, it is quite possible that a data principal may hold the data protection officer liable for breach of trust. Okay, so we should today consider that DPO will be responsible for implementation of the law in such a manner that the privacy of the person gets protected. Remember that we are calling the organization itself as a data fiduciary. That is one of the major differences between DPDPA and say GDPR, which calls the organization as a data controller. The data controller takes control based on the instructions given by the data subject. Whereas here, the data principal does give certain consents, but the person who is receiving the consent is not a mere servant of the data principal. He is actually a fiduciary or a trustee. The trustee should normally know more about what is in the interest of the data principal, and therefore a lot more is expected of him rather than simply saying that as per the letter of the law, I am correct. The requirement is to be correct as per the spirit of the law. So therefore, the data fiduciary himself as a company has the responsibility to protect the privacy, and the DPO who represents this data fiduciary also has these fiduciary responsibilities, and therefore he should always look at the look at empathizing with the data principle. This is one of the important, you can say, mental attitude which people will have to cultivate if they want to be good DPOs or even data auditors. When we come to trainers, apart from the in-depth knowledge, one needs interpersonal skills. Again, empathy to understand what the trainees require and able to have active listening capabilities, adaptability, continuous learning, of course, skills in presentation, and of course, passion to share without being selfish. If somebody thinks that I know, I don't want to teach somebody else the same knowledge because tomorrow he may become my competitor, then he would not be a good trainer. So I feel that some of you who may like to be trainers should also think that it is one of the important requirements of a trainer to be selfless and share whatever knowledge they know. Sometimes what they know may not be correct. Also, they may also have to learn from the others. And there, in last like this DPA, things will be evolving over a time. What I say perhaps yesterday may or may not be true today because the environment has changed, or maybe I myself might have evolved. So the trainer always undergoes a self-development, and if one is good in that, trainers also can make use of this particular training. But I know that one training cannot meet all the objectives, but it should open the door for meeting these objectives, but it should be supplemented with your own efforts. And in the minimum, I would like you to read the two books suggested, which is The Guardians of Privacy and DGPSI. In our physical programs, we actually made it part of the cost of the program and then distributed it free. But for virtual program, we have not been able to do that. But at the same time, of course, if you can purchase that physical books, it is fine. Otherwise, at least the Kindle versions are there, which are less expensive. But I feel it is good to go through that, and they will be important for passing the examination also. We are, of course, sharing the PPT copies and others, which itself is a good material. Rest of it, of course, is what you pick up during the discussions. And as I said already, GDPR is a gold standard, but you need to still look beyond GDPR, beyond ISO 27001 to really understand DPDPA as a law, as well as DGPSI as a framework. Many times people think that I am against ISO or GDPR. So that's why I always have Ramesh with me, because he's a big supporter of ISO. But I have always been of the view that we need to actually grow out of our shell and then try to learn something new. Okay. I would urge every one of you to follow the Hindu philosophy of questioning, exploring, and introspecting. It is not that there is one book which you can follow and everything you follow from that. In fact, I am reminded time and again that even in Bhagavad Gita, after completing all his discourse to Arjuna, Krishna finally concluded that I've explained to you whatever I wanted to explain, given you all the secrets. Now it is for you to ponder over it and then do as you wish. See, this is what we need to actually remember, that even after you hear what we say, maybe read what we write or something like that, ultimately you should be able to introspect yourself and come up with your own understanding of the topic and convert it into the requirements of implementation. The schedule is 10 to 1 on Saturdays and Sundays starting from today. Examination can be taken up subsequently We will give at least 15-20 days time, maybe towards the end of May. We will give you the PPT copies. Books will be available in Kindle version. And as far as making the recorded versions available, we have to still take a decision. We may be able to provide the recorded versions up to the time we prescribe for the first examination, which is, as I've indicated, end of May. So within that, if you want, we may give you an opportunity to make references. But because the recorded version is there, please don't skip the sessions, because there is always a difference between listening to the recorded version and then listening directly and having an interaction. Now, today we will be focusing more on the understanding of the concept of privacy and maybe to some extent applicability and legal basis. Then tomorrow we will discuss several case studies. In fact, case studies we may start even today to understand the DPDP risks. And then next week we will be going into some specific challenges or in implementation, including the consent manager, cyber insurance, data breach notification, reasonable security practices, etc. We are also trying to bring a discussion with professionals on how to use GDPR and ISO 27001. And then on 20th April, we may also have another industry panel, which will help us understand things better. And we will continue to discuss on the rights management, grievance management, nomination management, etc. The last week, we will be focusing more on the DGPSI, the principles, the two versions, DGPSI Lite and DGPS Full, the data trust score, and also have certain discussions. So this is the general information which I wanted to give before we start. And every day in this 3-hour session, by around 11 o'clock or 11:15, we will have one small break of 15 minutes so that we will have 2 sessions of approximately 1 hour, 15 minutes to 1 hour, 1.5 hours to give a small break. So what I have so far discussed about the program and other things, if you have any questions, please let me know before we proceed with the discussions on introducing FDPPI, etc. Yeah, any questions, please?
There are few questions. At least one question I saw in the chat, so probably you can pick that up.
Okay. Why is the Act limiting to digital data only? Okay, I will discuss that in detail later on. But see, when the Act says that this is applicable to digital personal data, it is expecting that our existing laws, etc., should take care of the privacy related issues regarding the non-digital data. In fact, you just wait. In the next session, I will try to see how this particular concept evolved as the immediate requirement. Okay, later on, maybe others will also come in. And as of today, let me tell you, there is very little non-digital document available in the business world. Okay, because if information, personal information is collected manually, later on, if it is digitized, it is considered as coming within the provisions of this Act. Okay. Now, what do you mean by digitization? If you collect a visitor's register in a manual form, but then pick up a phone and make calls, you have already converted the manual information into digital information. Okay. Then if you take a printout from a computer, it is already called electronic documents under Information Technology Act. If you collect any manual information with the specific process in your organization that it will be later on entered into a computer, a data entry process is there, then it is a manual information meant to be converted into digital form. So that also becomes a digital information only. So beyond this, there is very little data, and maybe the kirana shop or somebody who is small person, he will not have the burden of this act if he's maintaining his customer's account in a notebook or something like that. What are the dues, etc. So maybe the government wanted to give some kind of leverage to people who are not accustomed to digitization, because in India we have a law, and the law is applicable to all villages and everywhere. So they have to also take into account the possibility or practical difficulties involved. So they said low-hanging fruits we will capture first. In fact, the Puttaswamy judgment, the act, the judges also said the reason why we are thinking of all this privacy is because of the uh, issues arising out of digitization. So I think that was how it came into being. Is there any clarity on derived data? Shashi Kumar, what do you mean by derived data?
So derived data is suppose I give my name, date of birth, and some of my medical details for some insurance coverage.
Okay.
Now I use this data to derive certain aspects. Sometimes we derive it in aggregative way. For example, I derive by district-wise
Understand.
data.
Okay.
Sometimes I derive it without aggregation. So how
Yeah.
are
Okay. Now we will be discussing this under the definition of what is personal data, or what is personal data to which DPDPA is applicable. Okay, I call that as DPDPA protected data. Like in HIPAA, we call some data as protected health information. That is that information which is protected by HIPAA as a law. Likewise, in India also, we have personal data. Not all personal data is protected under DPDPA. So we may have that class of data which is for which applicability is there as data, DPDPA protected data, or sometimes I use an abbreviation DPD. Now, a personal data is one which, from what you have as data, you can identify an individual out of that. Now, what is that data? That data may be a collection of a few parameters. For example, there is name. Name is one data. Okay. Now, is it identifiable to a particular person? I know the name, but who is that person? It is not possible to have one data parameter and identify a person. When you add more parameters, like say Vijay Shankar, chairman of FDPPI, then your identity is increasing, okay, or changing, okay. In a corporate environment, you have got an employee, Chandrasekhar, there may be hundreds of Chandrasekhars in your company. So the name itself may not be fully an identity of a particular person. So personal data itself is actually a set of few parameters which together identifies a person. Maybe in India, we can say a PAN card or an Aadhaar number is a good identity because it is unique, and there are public databases from which you can identify a person. If you get that kind of a thing, then you can say it is the core data. Okay. Now, when you talk of derived data, if you are talking of data which is aggregated without the individual identity, like the pseudonymized identity or an aggregated identity, then the derived data which you are talking of is not related to any specific individual. Okay. So probably you should segregate it as a different kind of data. In fact, if you go to the classification system which DPDPA has suggested, you may be surprised that we are talking of data classification into 31 categories. Okay. One of the reasons is that within the data, these differences are there. Data can be personal, non-personal. It can be personal, but coming under GDPR, not under DPDPA. It may be personal coming under DPDPA, but is exempted under one category. So there are various kinds of data. Now, when you de-identify a data, okay, and leave for example, health data you said, okay, that is a person who is a male, who is aged so and so, residing in the state of, say, some hilly region or something like that, is having a particular disease. Now, this data, if you don't identify it with an individual, is something which is devoid of identity of a particular person. And you should look at that as not necessarily a personal data. See, we may have to make a distinction between identity parameters and the full identity. So that way, these parameters, in HIPAA, we have got 18 such parameters, and in GDPR, people will say, is IP address a personal data? The first answer is yes, but actually, unless the data on hand itself is capable of identifying an individual, it should not, in my opinion, be considered as personal data. Now, if the same organization is having multiple identity elements together which you can identify an individual, even if some parameters are with division A, some parameters are with division B, they may be physically separated, but the organization is same. Your Bangalore office has some information, your Bombay office has some information, but as an organization, if you combine the both, you can say that this data is identifiable to such and such a person, then it should be considered as personal data in the context of the organization. Now, when you start aggregating, the aggregation can be done, and most probably the requirements of most of the aggregation is that we don't need to understand the name of the person. We need only certain parameters. As I told you, in the case of health, you need to know the gender, you need to know the age, some racial elements, kind of a thing, to understand how does a particular disease affect one particular kind of people, and that is the objective of, let us say, the aggregation. Then the aggregated information is a report which does not reflect an individual's identifiable health information. So in my view, that should be considered as not a personal data. But you may ask me a question that even if some data is anonymized, pseudonymized, de-identified, what if somebody runs some analytics and identifies that particular person? If the data is being capable of re-identification by applying certain techniques, then should you consider the data itself as identifiable? Now, my view in this is that by a normal, prudent person, in a normal circumstance, if I am not able to identify, then it should be considered as not identifiable, so not personal data. But if you, with some special knowledge, using some special software, and then putting some special efforts, you can identify that data, then you are working like a hacker. You can hack information out of any information. So that additional efforts which a person uses, I cannot be held responsible. If I'm a data fiduciary, I have released certain data as a pseudonymized data or an anonymized data with a certain standard of anonymization or pseudonymization, which is not plain text. It is not easily decipherable. I am believing that it is a de-identified information which I can share. It is not a personal data. I can share for research or some other purpose. But I cannot take responsibility for all the works which a specialist hacker can do to run his own analytics and identify the data. We have to segregate these two, that any data which is de-identified or pseudonymized and disclosed as per the provisions of DPDPA, even encrypted, let us say, if it is later on decrypted or identified, then the person who caused the de-identification should be considered as the person who is responsible for identifying that information, not the data fiduciary. In fact, under our theory of data, I have specifically mentioned that the data goes through a life cycle. Initially, it is just raw data, some binaries. You combine together and it becomes understandable data, maybe personal data. You encrypt it, it becomes encrypted data. Pseudonymize it, it becomes pseudonymized data. Subsequently, it can be reconverted into identified data. Now, each of these is a process of transition. That is, data undergoes a transition or a life cycle from raw data, zeros and ones, to various kinds of, you can say, aggregated data. In fact, putting 8 bytes together is itself an aggregation of binary to give a meaning. So when you do that, that process, whoever does that process, he should be responsible for the consequences of the process. So if I've got a de-identified data, but I use my skills to identify it, I should be responsible for that identification, not the person who gave the de-identified information in good faith under a reasonable security of de-identification that it was not identifiable. In fact, if you go back to some of the earlier say suggestions under PDPB and other things, the ministry was expected to actually give a standard of anonymization. Okay. But of course, what the current thinking of the government is that if the government comes up with anything and call it as a standardization, that limits the security to that level. Whereas if you say you are the data fiduciary, you have to determine what kind of standards you have to use to anonymize so that nobody else will be able to identify it. Then that responsibility is with you. And as technology moves forward, it is your responsibility to take such technology which is currently good enough for the risks which the particular data represents. So if I have got a health data, if I have got a financial data, I have to use certain standards which are much higher. If I have got some other data, maybe the standards may be different. Now, this decision is now left to the data fiduciary. One of the reasons why I appreciate the current approach of the ministry in saying that we will not give too much details in our rules. In fact, I have also been telling the ministry, don't take the bait and go about giving detailed rules for everything. Okay. Instead of that, leave it to the due diligence of the data fiduciary. You see that kind of a paragraph in the DPDPA rules when it comes to the artificial intelligence. Okay. It very cleverly says that the data fiduciary who is using the artificial intelligence is expected to apply due diligence to ensure that the algorithm is compliant with the DPDPA. Same in GDPR or in the EU, they go about having an ISO 42001 or 011 or some big standard to say what is the standard of AI. Now we are simply saying that assess the risk, be accountable for the risk. If something goes wrong, I will catch you. So the deployer of the AI is responsible to identify the risks and then apply due diligence. The word due diligence is a very generic term, and it is again something which moves with the time. So we have adopted this strategy of considering the data processing company, which handles the purpose and means, whom we call as the data fiduciary, as the person responsible to determine how they should go ahead with de-identification or anything like that. And I think that is what perhaps you should need to look at. Okay. That is, we may still discuss more about this derived data as we go along, but I think you have asked a good question, so I spent some time on that. Sagar?
Sir, just one query here. As you said that government is keeping it open for data fiduciaries, data processors that they put up appropriate control. Now, just for an example, under the definition of data masking, encryption is also considered as a one of the technologies for masking, which is
Okay.
now, if I say that I will just encrypt it and I will not do anonymization or pseudonymization, I will just encrypt it, and then something goes wrong, then how do I prove myself that whatever control I had put was appropriate?
Okay. Now, anyway, the way you have tried to anonymize or apply security procedures before disclosure is to be documented. Is that not? That is a reasonable security practice. Rule number 6 and the draft rules also. It says you can use anonymization, data masking, encryption. These are all alternate names. Now, which one you use for a particular thing will depend. Now, when we normally say masking in, let us say, your PCI DSS area, we are talking of withholding part of some information and say last 4 digits of Aadhaar is available. Maybe that is what I look at as masking. Okay. But when you say encryption, the entire data gets converted into an encrypted form and you need a key to actually decrypt it. But if you don't have the control on the key, like people who write their PIN on the back of their ATM card and they lose the PIN along with the card. If you don't do that, okay, then you have taken a reasonable care. Now, whether that encryption was easily decryptable or not is a matter which the industry has to decide. Okay, whether you have used reasonable level of encryption. But if you have used a reasonable level of encryption, but there is an intelligent person who has decrypted it, I am bringing in the concept that I have disclosed encrypted data in good faith and with reasonable security. If somebody has used a brute force attack or quantum computing and broken it, then he has taken the special efforts. Please punish him as a hacker. Okay. And tell him that you have unauthorizedly accessed the plain text within an encrypted text, and it is punishable under Section 66 of Information Technology Act or Section 66F of Information Technology Act. That is the view we have to take. In fact, this can be one of the disclosures. When you disclose encrypted information to an authorized person for some thing, you please add a disclaimer that breaking of this security feature may result in your taking the responsibility for the unauthorized access. Please make that as a footnote or something like that, or make it as a part of your policy. In your policy document, you say that in the disclosure policy. See, in DGPSI, we will be having a disclosure policy. In the disclosure policy, we will say when we disclose personal data, to whom we disclose, what should be the procedure for that. So we disclose the personal data, let us say, to authorized persons, including a law enforcement person. Now, the law enforcement person, even under Information Technology Act, when he receives confidential information from a company, he is responsible for further security. So when you give an information to the police, tell him that if this information is lost, you are going to jail, not me. Okay. And that is there in Information Technology Act under Section 68, if I remember correct, that the organizations which receive the information are responsible under any approved disclosures methods is responsible for further security. So likewise, here also, when you adopt an encryption system with which I consider as reasonable. Now, the question reasonable is again a vague term. So it will be again, you have to apply on a context to context basis. And if you have adopted a reasonable method, then you will be considered as having done your duty. So this should be part of the disclosure policy. And in the disclosure, please alert the recipient that if you do this de-identification, then you are punishable. If possible, mention Section 66 of Information Technology Act or something like that, so that they will check with their legal department and understand. Okay.
Thank you. Thanks a lot, sir.
Yeah. Okay. Now, I think the next 5-10 minutes we will have this FDPP introduction and then take a break. Ramesh,
Sir, I think you covered mainly,
yeah,
but very quickly to team, very good morning and warm welcome to this program. And I can assure you, being part of FDPPA for so many years, you have taken a right decision and to work with Mr. Navi for this program. To summarize, I'm sure many of you would have heard about FDPPI. FDPPI is a kind of organization which is not a kind of commercial or something, as we all know. It's for us, right? We say that it's promoted by the professionals in data protection related activities, right? It's a Section 8 company, and we have almost around 300 plus people who are part of this organization at this point of time. Wherein, when I say 300 plus people, members I'm talking about. And we have at FDPPI programs ranging from what you're going through now, going to go through CDPODA DA training. Like that, we have plenty of trainings which helps us in specializing the particular areas, whether it is a GDPR, whether it is a HIPAA, whether it is an international laws or local laws and so on. But however, this program is going to be mainly concentrating on DPO as well as DA. DA stands for Data Auditor. And this is promoted by us once again, right? All of us, it's for us, it's by us. And the key is the participation by each one of us. And Mr. Navi already, who is the promoter and chairman of FTPPI, I don't think I need to introduce him. We all know, the industry knows. I call Mr. Navi as a brand. So how we really wanted to make use of the brand, absorb the knowledge what he has got. Would request you to be, alert on his blogs, his messages. He's too fast. Sometimes we'll be missing his messages too. And we do have Mr. Nagendra, who is the director from the day one, who comes, so who is a GRC professional with the industry, and myself, Ramesh Venkatraman. I am part of the board since the last 2-3 years. Now, interestingly, if I had to summarize the other members, the chapter presidents, etc., whom all we have here, right, all are very well experienced. Let it be on information security, let it be on data privacy or data protection laws or legal fraternity. This is one forum. We have a combination of all these people. We have seniors from human resource, we have people from legal, we have people from technical, and so on. So that is the advantage. And every week we have one particular program to introduce to you guys is Jnanavardhini, which we religiously have it on every Wednesday between 7 to 8. Please block your calendar. And once when you become the part of the Telegram group, which Manju already had sent the link, be a part of it, and you will start whatever questions had come so far. Like this only, there will be a good discussion on a particular topic by them. Whether even sometimes we discuss about tool related, technology related, right? To understand more about the de-identification or anonymization or pseudonymization, etc. And we also, FDPP also provides consulting, again, under the leadership of Mr. Navi. We have supporting members. When I say supporting members, they're all like, they all having their own organizations. Some of them are already there. Subraidu sir came up. I think Mr. Ashok is also there. There are lots of people where they have their own setup. They have their own skilled and competency resources where the FDPPI works with them, in a close relationship, of course, under the guidance of Mr. Navi. I think I will stop here. The last one, which Mr. Navi already talked about, is the framework, which is the game changer for all of us in the call while implementing the DPDPA 2023. Right now, we do not have yet any framework in India, neither by the government or by the industry. I can be confident and you can be rest assured that DGPSI, what we are going to cover as part of this training, would help you Now, I heard about many of you are having a kind of strong experience in information security, which will be an added advantage for you when you look at the controls and the processes what we promote as part of this DGPSI. Let me stop here. Let be participative. I always say, right, Watts Humphrey's a famous quote, don't worry about reaching the destination of, clearing the exam. Enjoy the journey. Be with me, listening to Mr. Navi and to everybody here, because questions are going to come from different directions and different dimensions. Be alert, try to absorb, try to enjoy the program. Thank you very much. And I will also be part of this all the weekends. Let's have a good interaction as much as possible. Thank you very much. Yes, Mr. Navi.
Please keep raising your questions, because it is through questions that we will be able to dive deeper into the act. Okay. Yeah. So as we all know that DPDPA 2023 was passed on 11th August 2023, and the rules have been in process. It has been draft rules have been given for public comments. Public comments have been collected, and the government is working through that. And it appears that government is also simultaneously trying to work through the changes which are necessary in Aadhaar and other things, so that starting from the day it is notified, they don't see litigation starting with Supreme Court, because in India we always have the kind of development that once you make a law, immediately Supreme Court will be called upon to question the law. It is happening in the work law, and it will definitely happen even after the rules come up. Okay, so government is a little careful and trying to ensure that whatever changes needs to be made are made before they finally notify the rules. Of course, don't expect too much from the first set of rules to be notified, because it will only pave the way for setting up the data protection board, and subsequently a lot of things have to happen under the guidance of the board. The board will have to come up with certain procedural requirements. So even in the rules, you know that only 4 rules are becoming effective, notified immediately. The rest of it will take its own time. So it is only an indication of the government's willingness to progress further, rather than making a substantial change between today and tomorrow when the rules are notified. But remember that there is a law called Information Technology Act 2000, which will remain even after DPDPA is fully notified and become effective. Even after Section 43 capital A of Information Technology Act is considered repealed after the DPDPA comes into effect, still ITA 2000 will remain. There will be Telecom Act 2023. There will be Consumer Protection Act 2019. There will be new laws like the new AIPC, new CRPC, new Indian Evidence Act, as well as the new Aadhaar Act, which are all relevant for data protection. And AI will, of course, bring its own complications. And maybe we may even have a AI regulation coming up in the next year or something like that. So all these things are the background in which you have to look at the DPDPA. Okay, the large penalties have made compliance a key activity for the industry, and therefore there is a request from the industry on professionals who can understand and help the industry in being compliant. Okay, so therefore all of us needs to upgrade ourselves to become something like an empowered CIO or whatever else designation we hold to be capable of handling the DPDPA era. And if we don't catch the bus now, we may miss the opportunity altogether. Let us not be complacent. Now, people will be thinking, will AI eat into the opportunities? Because many people are saying that you can have a AI lawyer, you can have a AI judge, AI court. So lawyers are not going to do much. They also have to refer to AI, chat GPT before they write their petitions. And if that is the case, then in the compliance also will an AI software will automate the entire compliance. I can just plug in and then I am compliant, kind of a thing, or an audit. If I want to do an audit, can I just plug in a software and then come up with a report in a second or something like that? So this question will remain. In fact, we know that AI has advanced to such an extent that this one of the companies, Dictator, has even appointed a humanoid robo as its CEO. And lawyers here are aware that there was an instance in USA where a petitioner had filed a petition which had many case references, case laws, but unfortunately they were all stories created by the AI and it was not true. So when you apply AI, particularly large language models, and use it for something connected with law, it is always a daisy situation because techno-legal interpretation requires a very high level of cross-disciplinary skills. And ordinary AI is not going to help you because normally AI is only a tool, and depending upon our input, depending upon the machine learning, you will get the output. If your software is developed on the basis of some machine learning outside the DPDPA area, then obviously its decisions will not be accurate. Unless we come to a situation where there is a super intelligence, you will not find an automated solution for DPDPA compliance. In fact, what we may require is a cyborg who is a human, has his human intellect, and at the same time is also having ability to make reference to the data which is there on Google or on a database managed by the AI community. Okay, so until that time, you all have a need to be there in the forefront. Similarly, when we talk of the frameworks, okay, the first thought is that there is already a developed framework, ISO 27701 or ISO 27001 made for 2022, which calls itself as privacy oriented. Whether we can fit DPDPA compliance into these existing models is always a question which arises in your mind. Particularly, some of you may be even qualified ISO auditors also. But I would always like to say that you cannot fit Sunil Gavaskar into the T20 team today. You would rather prefer Surya Kumar Yadav. Not for any reason that Gavaskar is inferior. He is in fact one of my favorite persons. India should be proud of but I would definitely be happy with him as a commentator today rather than a player in the T20 team. That really underscores the role of the current frameworks, whether it is the ISO framework, the GDPR framework, or even the NIST framework. All of them are good, and people who are experts in those things may have a loyalty to the existing frameworks, but remember that they may not be the right frameworks for the DPDPA compliance, and therefore, please look at DGPSI with an open mind. DGPSI is a framework which is specifically developed for DPDPA compliance. And in fact, as of now, there is no alternative to DGPSI for DPDPA compliance. You can always use your own intelligence and work without a framework. Framework is not mandatory for compliance. For audit, it may be mandatory if the audit is done with reference to a framework. As of today, there is no framework which the government has prescribed as the required framework. So in future also, it is unlikely that the government will say that if you are compliant with XYZ framework, you are deemed to be in compliance. The government did make a mistake of that nature when Section 43 capital A rules were notified in 2011, when the notification did make a mention that Section 43A compliance is deemed to be satisfied if you are ISO 27001 compliant. This was very seriously objected to by me, and the ministry later on clarified that ISO 27001 is only one of the frameworks which can be used. So that situation was decided in a different manner with the clarification, though ministry was not happy that their decision was questioned at that point of time. I hope that today they will not make the same mistake. Even for DGPSI, they may not say that if you are DGPSI compliant, you are DPDPA compliant. There is no such thing as far as the legal compliance is required, because the law itself is a core framework. So everybody has to be compliant with the law. But unfortunately, law can be interpreted in multiple ways. That is why in every case you have a lawyer on one side, another lawyer on the other side. Both of them will be debating on the same issue, but will be interpreting it differently. The same way in the DPDPA also, there can be different interpretations. And DGPSI will be one such interpretation, and we call that as a kind of jurisprudence on DPDPA. And hopefully that is one of the best which will be available. Today it is the only one which is available. Tomorrow there will be others who will be coming up with their own frameworks. Then there will be something which you can compare. But don't expect the government to come up with and say that DGPSI compliance will be considered as deemed compliance of DPDPA. There is no such requirement, and we also don't recommend that, because interpretations have to be made in the particular context, and frameworks can only guide you up to a particular point, but later on it has to be interpreted by the organization with reference to the context. But we will discuss DGPSI in detail, because an audit is possible under the DGPSI framework. It is a reasonably good verification of an organization whether it is DPDPA compliant or not. We have the DGPSI Lite, which has got 36 implementation specifications directly mapped to different sections of the DPDPA. And therefore, if you check each of those implementation specifications as an auditor and be satisfied with the quality of the responses and evidences presented, you can reasonably be satisfied that that organization is perhaps DPDPA compliant to a reasonable extent. The full version of DGPSI has got 50 implementation specifications. It is much more detailed, and it is a governance model because it includes the need to be compliant with the Bureau of Indian Standards, one draft standard for data governance, along with the need to be compliant with ITA 2000 and other associated laws. So DGPSI is definitely something special, but the need to use a framework arises more in the audit. At the time of implementation, understand DGPSI and try to be ready to be audited under DGPSI. You will be far ahead of others even when you get off the block. Start early so that you will be able to reach your goal ahead of others. Please remember to check the sources of reference. You please go through navi.org from time to time, because that is where all the academic issues will be discussed. fdppi.in will be only like a corporate website. So more information you will get under navi.org. Then as far as the Act is concerned, there is a dpdpa.in website that itself has got a link to the DPDPA rules, both the first version and the current version. And when the new version comes, that will also be available there. Then you can also follow us on the Telegram and the LinkedIn. These are the two books which I was mentioning. Please go through that. Now, with this, we will go through the essence of DPDPA 2023. The first thing which you have to observe is section 44 of DPDPA 2023, which talks about the relationship with DPDPA 2023 with the other law called Information Technology Act 2000, ITA 2000. Now, this section is important because in a way, this will determine the applicability of the act as of today. Now, if somebody asks, is DPDPA applicable today? I would like you to think around what I'm going to say now. Now, this section 44 says, one, that the Information Technology Act 2000 will be amended. First, section 43, capital A will be omitted once this section 44 of DPDPA is notified. Secondly, under section 81 and section 87, a small consequential corrections will be made. What is important under section 43A, I will come to that. Now, in the Information Technology Act itself, there is a section called 81, which says that act will have an overriding effect. The provisions of this act, which is ITA 2000, shall have the effect, notwithstanding anything inconsistent therewith, contained in any other law for the time being in force. This was when ITA 2000 was enacted, first in October 2000, and then amended subsequently with effect from October 2009. Now, in this section 81, Digital Personal Data Protection Act is provided as an exception so that it will, whatever rights are there for people under DPDPA will be still available. It will, as long as there is no inconsistency between ITA 2000 and the DPDPA. Okay. Then when you look at section 43 capital A, okay, people are today asking, now section 44 says that 43 capital A is omitted. Okay. Then there was recently an argument in a court where one of the petitioners said 43A is not applicable. Therefore, no petition under 43 capital A should be considered. Then if you ask him, then does it mean that I can bring the petition under DPDPA 2023? The same lawyer will say, no, no, that has not been notified. So it is not the intention of the government to create a vacuum between the removal of section 43 capital A and the ushering in of the DPDPA 2023. So as of now, 43 capital A will continue to apply until section 44 of this DPDPA is specifically notified. If you look at the DPDPA rules as of now, there is no specific mention of section 44 under the notification. Okay. Now, unless when they come up with the final notification, if they say all other sections other than what has been specifically mentioned will become effective on such and such a date, they may have to make a mention like that. But once section 44 comes into being, the 43 capital A will go off. Now, what 43 capital A said is being repeated by DPDPA as an act. For example, if you see section 43 capital A, it talks about compensation for failure to protect certain kind of data. It applies to sensitive personal data. It applies to body corporates. Of course, body corporate includes sole proprietorship and other things, so it doesn't make much of a difference. So it applies to body corporate or the organizations, does not apply to the government. That is the only difference. Okay. Since they are even the so-called instrumentalities of the government. Okay. Then it applies to sensitive personal data. It expects the companies to adopt what is called reasonable security practices and procedures. If they don't do that, then they will be liable to pay damages. That is what the section talks about. Reasonable security practices were elaborated in the rules which were notified in April 2011, which had various requirements, like that you should have a policy for privacy, you should obtain a consent in writing, disclosure is permitted only after prior permission. You may transfer the sensitive personal data only to such countries where there is the same level of data protection. You should implement security practices and have comprehensive documented information security program. These were all part of the what you sometimes refer to as SPDI rules, that is sensitive personal data rules. Okay. But essentially, all these are now replaced by section 40, various sections of DPDPA from 1 to 44. Okay. Now, it is here that these rules made a mention that in the event of an information security breach, the body corporate or a person on its behalf shall be required to demonstrate, as and when called upon to do so, by the agency mandated under the law, which can be considered as certain or whatever is that they have implemented security control measures as per the documented information security program and information security policies. That is, the reference at that time was more or less self-drawn, in the sense that a company should have its own control measures, and when something goes wrong, they will have to demonstrate that they were at least following whatever they themselves had given up as their policies. And anyway, this reasonable security practice will come under question only when somebody has claimed a compensation alleging that the company had not been able to secure the sensitive personal information, and therefore the courts would come into being. The complaint would first go to the adjudicating officer, then it will go to the TD SAT, and then it will come to the High Court and then to Supreme Court. So the Supreme Court or the judicial system would have oversight on whether the security was reasonable or not, whether there was proper documentation, whether the implementation was in tune with the documentation. These issues would all be covered in the trial of a particular case which arose due to section 43 capital A being invoked by an individual who had claimed some kind of a compensation. So that is how section 43 capital A applied. It could normally be invoked only when somebody had suffered a loss, because ITI 2000 was more a cybercrime related law, and only when a person has suffered a loss, he could invoke the law. The cause of action should have been there. Whereas DPDPA is more like a compliance related law. It talks about whatever was a reasonable security practice. Now it says that reasonable security practice is the law. Okay, it is specified in the law, and therefore not having reasonable security practice is itself a contravention of the law, and penalties could be applied in such cases. There is no need for a data breach. There is no need for a loss having been occurred, and no need for somebody to claim that loss for DPDPA penalties to start applying. For example, if a company was required to have a DPO appointed, they did not do that. That itself is sufficient to bring in some kind of a penalty. So the DPDPA law is different from ITA 2000 to the extent that the penalties can be applied even when there is no data breach or actual victim of a data breach. But ITA 2000 was limited to that extent, and therefore we have not heard much of ITA 2000, though some of you are aware that I was handling the case against ICICI Bank, phishing case, in which ICICI Bank was asked to pay compensation to the victim, who was an account holder who had lost money. Subsequent to that Uma Shankar versus ICICI Bank case, there have been many cases in which the adjudicator or the appellate tribunal have provided not only compensation for the actual money lost, the interest payable on that, but also certain additional consequential expenses such as compensation for the harassment undergone and so on. Okay, so that has already happened. But all that was for compensation payable to the victim, like a data principal, okay, who is alleging a lack of security practice. But what DPDPA now brings in is a penalty to be applied on the organization which fails in its reasonable security practice, and the individual data principal will continue to make use of the facilities available under ITA 2000 to recover his compensation. 43 capital A may go, but there is going to be 43 linked to section 66, and under section 43, the data principal can still make a claim for compensation. That is why we say that after DPDPA comes into existence, ITA 2000 will continue to remain, and it will be perhaps more active than what it is now. Now, because DPDPA 2023 is a continuation of section 43 capital A, you remove 43 capital A in one hand and then introduce 44 sections of DPDPA, we consider DPDPA 2023 as due diligence under ITA 2000 till such date actually it becomes fully operative, which means that as of today, DPDPA 2023 is something which should be considered as legal intention, which should be considered as due diligence under ITA 2000. So therefore, I would like people to consider compliance of DPDPA from yesterday, not wait for the rules. And apart from section 43 capital A, which goes out, you will be having section 43, the adjudication facilities which come under section 46, and other sections like 72 capital A, which is very much relevant for the data protection, particularly the data processor contracts, and then 67C on data retention, 66B on the use of stolen data, 66C and D on impersonation, 66E on digital photography, which can be called as obscene, 66F, which is the cyber terrorism clause. All these clauses will remain and will continue to apply to companies, along with section 85, which escalates the contravention of a company to the person in charge of business, to the CEO, to the director, and so on, who will all become liable criminally for offenses coming under ITA 2000. When a data breach happens, if that is considered as an offense under section 66 of Information Technology Act, and if there is some kind of a negligence of the company because reasonable security practice has failed, then the company will automatically become responsible for the liability. And if it is criminal liability, then company cannot be put in jail. So one of the executives may have to face the possibility of imprisonment. This is not fiction. It happened way back in 2004 in the Bazi.com case, and the CEO of Bazi.com and as well as the general manager of Bazi.com had to fight their case for 8 years in Supreme Court before they were, of course, in that case acquitted because of a technical failure by the police in pressing the charges. Otherwise, they would have been liable for 5 years of imprisonment for violation of section 67. Now, in the last few days, some discussion is going on section 44, subsection 3, which makes an amendment to the RTI Act. I feel most of the time that this is not a very serious concern for companies. What it says is that RTI Act has got an obligation to disclose information to somebody who raises the query, but the person who is giving or disclosing that information can refuse to give the information in case the information sought to be disclosed involves infringement of privacy of some other person. So the amendment earlier it said that it cannot be released provided there is a public interest involved. Okay, there was a need to perhaps give evidence that if I release this information, then if I don't release this information, some public interest is being defeated. Therefore, I will have to release the information even if it infringes the privacy of an individual. So this justification had to be given by the officer who is disclosing the information. Right now, the amendment only says that if something infringes the privacy of an individual, then there is no obligation to disclose. So it is just a simplification. It simply says that there is no need for an extra justification to be given, but protection of privacy is essential. Now the question is whether we are talking of the privacy in terms of an official. Like in the RTI application, most of the time, we would like to know who is the official who gave a particular order or something like that, because we want to see whether there is any corruption or something like that. That involves the privacy of an official who is holding that position. So the RTI disclosure may still talk about the designation, saying that this particular order was issued by so-and-so as a secretary or deputy secretary or something like that. If the person wants to pursue further, then he can pursue further his personal action against the particular official. Now, anyway, any action against the government official needs prior permission and other things, so it is not something which will automatically follow. Now, there are many instances when an RTI information releases a set of information in which a whole lot of privacy information of other people may be released. For example, you ask some health information about one primary health center, who are all the persons who have actually undergone a certain procedure in the hospital for a particular period. Then the RTI may give a list of 120 people whose names, ages, and etc. So that may become a release of private information. And now the person who is supposed to disclose have to take a view that this disclosure will involve infringement of privacy of so many people. Without their consent, I cannot release this information. So this is what the amendment says, but people are making a hue and cry out of things which are not relevant. But from our corporate point of view, this is not of much significance. So we will, for the time being, leave it aside. So today, if there is a DPO in India, then he should be reasonably conversant with the relative laws like ITA 2000, the Bharatiya Sakshya Adhiniyam 2023, which has got section 63, Bharatiya Nyaya Samhita, which is the previous IPC, then the Consumer Protection Act, which has got a provision related to dark patrons, and then Aadhaar Act, Telecom Act, and so on. Now, DGPSI full framework tries to incorporate these requirements along with the draft standard of data governance suggested by BIS. Okay. Now we will come to some specific issues of the Act, such as the applicability. Okay. I will just present 3 small case slides, and I would like you to take 1 or 2 minutes to think over it, and then we will discuss. Okay. Now the first instance, there is a company A. It has got a website. It provides tourism packages in India. Now it is running one special campaign for Ayodhya Ram Mandir tourism from its website. Okay. It could have been a Prayagraj also, right? Some specific event. Okay. Now there is a French tour operator who contacts this company for a package tour of 50 tourists from France, obviously. And the first question he asks is, are you GDPR compliant? Okay. So this is one instance we will discuss. The second one, Mr. X is organizing an inter-apartment cricket tournament and is collecting the personal information of about 1,000 apartment owners, their family members, etc., for running the tournament. Okay, this is second. Third, Bharat Apartments has placed 100 CCTV cameras in their premises. Obviously, for security purpose, it is managed by a security agency, which also manages a visitor management system, which includes a face recognition to match the visitor's movement within the premises for security consideration. Okay, so if a person enters and says, I want to go to flat number so-and-so, building number so-and-so, then subsequently other CCTV cameras will be watching whether he is going to the same flat or he is going to a different flat. Okay, these are all common softwares which are there. Now just think on these three instances. Let us see how DPDPA 2023 is applicable to these instances. Okay. To determine the applicability, you need to ask some of these questions. Are we talking of personal data or are we talking of non-personal data? Which also means that when does personal data become non-personal data or vice versa? Now, data on website visitors. There is, I have a website, people are visiting on the website. Is it personal data? Then is the data identifiable to a person? Okay. If you have additional data that is also shared, then does it become identifiable? If there is no additional data, for in this case, for example, we are talking of a French tourist or something like that. He may simply say, I want 50 people package. Okay. That time there is no identity. Okay. So when he submits a full list of people, then perhaps it may become identifiable. Now, where is the data processed, whether it is processed in India or whether it is processed outside? These are the issues which you will have to be looked at. Obviously, some of you will be asking, do I have a checklist template for applicability? Yeah, any reactions to this? Any of you?
Yes, sir. I think DPDPA applies to all the three situations
Okay.
because data is processed locally. Even the European data is processed in India. So DPDPA applies to that situation also.
Okay. There is a question. Are you GDPR compliant? What will you do? What answer you will give?
Of course, I'm not familiar with GDPR provisions, but I feel that he should be a GDPR compliant also because he is processing the data of Europeans. Of course, I'm not very familiar with those provisions, but that's my feeling initially.
Should be GDPR compliant, sir. I also feel.
Yeah. But should we also ask him where the data is stored for him to be a DPDPA compliant, sir?
Okay.
Where the data is stored and so on.
Yeah.
Sir, but GDPR is not applicable for Indian context, right? So he doesn't need to ask whether we are GDPR compliant. We should be more of PDPA compliant.
Okay.
So campaign is for the Ram Mandir visit in a European website, then probably they have a right to ask whether they are GDPR compliant. I mean, if they are visiting an Indian website and then they are looking into it, so if they are taking a tour with an Indian company, then it is probably a PDPA compliant. But if the campaign is run in a website that is posted in, say, Europe, then probably the GDPR compliance can be looked into. This is my thought.
Okay. Yeah, anybody else? Now,
My view
Yeah,
My
really.
view is that for second and third, DPDPA might not apply for the second question and third question because it is not related to business purposes. But as far as the first one is concerned, GDPR compliance might not apply for the operator in India. Still, we might have to look into the contract or whether there are any safeguards which the Indian contractor has with regard to the data. But DPDP might also not apply. It does not apply for foreign data. No, that's my view. That's my view.
Okay.
So for case number 2, DPDPA may not apply, is what I feel. But in the first scenario, asking whether they are GDPR compliant, yeah, I think it makes sense because they will be processing in some way the data of European nationals.
Fine.
Before getting into that DPDPA complaint or GDPR complaint, we must clarify our doubts that whether
Yeah.
the PPA, like PIA processed, which is from EU citizen or Indian citizen. That is the first major question that we need to ask to
Okay.
get clarified more.
Now, as far as GDPR is concerned, GDPR says that it is applicable to residents in EU. That resident can be a European or other than European. But it applies to the context of processing of data related to the activities in the EU. Okay. But if there is an activity outside EU, okay, that is not covered under GDPR. For example, when a person is a European who is walking in the streets of Bangalore, he commits an offense or something like that, he is liable to the Indian Act only. Okay. So the GDPR only talks about the activities in the EU Union. It may apply to data processors outside the Union, and that is why we say it has got extraterritorial jurisdiction. But even that should be related to the data which is generated during the activities in EU. India also has adopted a similar provision under Section 3 of the DPDPA. What does Section 3 of DPDPA says? So that is the one on which applicability has to be decided. So the first thing it talks about is this act will apply to digital personal data, not the manual data. That is separately mentioned that if something is collected manually and subsequently digitized, then it will apply. So it will apply to the processing of digital personal data within the territory of India. So the first test you have to apply is whether it is being processed in India. Okay, if the processing is outside India, you have to look at it differently. Okay, so as far as the website, somebody correctly mentioned that if a person is visiting an Indian website, now the question is where is that data being processed? Okay, it depends on where it is posted, perhaps. Okay, ideally, if it is hosted in India, there is no doubt. Suppose an Indian company hosts data, a website outside India, then there is a question mark on where is it hosted. But Indian law normally recognizes data residency more from the point of view of accessibility. For example, there is one provision in Information Technology Act which says, if I am sitting in India with a residential address in India, but today I am in Singapore, and from Singapore I will send you an email, okay, to you, let us say you are in US. Now, that email is deemed to have been sent from India, not from Singapore, okay. Why is it so? Because Information Technology Act recognizes the person's legal jurisdiction for assigning any legal liability. So similarly, if a company is owning a website and that company is registered in India, is liable for Indian laws, perhaps it will be considered as data which is being processed in India. So therefore, it is to be considered as processed in India. Now, it's obviously digital personal data. Okay. So that class 3A is applicable. Now, if the processing happens outside India, then there is a subclass which says that if the processing is related to offering of goods and services to data principals in India, then even if it is being processed outside India, it comes under the applicability. Therefore, if this is a website which is providing some services in India, like this Ayodhya tour or something like that, irrespective of whether it is processed in India or outside India, still it will come under DPDPA. What it will not apply DPDPA is when personal data is processed by an individual for any personal or domestic purpose. Now, in the second case, some of you said it is not business, therefore it should not be coming under DPDPA. Now, and Mr. X is an individual. Okay. Remember that an individual also can be a data fiduciary under DPDPA if he is processing personal data for non-domestic, non-personal purpose. Now, conducting a tournament, inter-apartment cricket tournament, do you consider it as a personal activity or do you consider it as a domestic activity?
It's definitely a social activity, which is
It's
outside of personal.
Okay, it's
Domestic.
outside of personal,
It's
outside of domestic, which means that it is coming within DPDPA. Am I correct?
Correct.
Okay. Then personal data that is made or caused to be made publicly available. This is also, it will not apply. So DPDPA will not apply if the personal data is made publicly available or caused to be made publicly available by the data principal. If the person himself puts it into the public, then that may be exempted. This, of course, depends on the context in which a person has himself put up the information. But even this has got a purpose. Many times we have data on the LinkedIn. I put it up on LinkedIn, so I have made it publicly available. Okay, but I have made it for a particular purpose. So for that purpose, you can say that DPDPA is not applicable. But if it is to be used for any other purpose, then perhaps this exemption may not be available. Okay, so we need to look at the Google data or data which can be scraped from internet, whether they were made publicly available by the individual himself or not. If somebody else has gathered my data and put it up on the website, then a third party cannot use that, saying that it is already made public, therefore I can use it. This is where it becomes use of stolen data or unauthorizedly acquired data. And you remember in Hyderabad some time back, there was a data seller who had created database across the country and was selling it, and police arrested him and then might have booked a case under ITA 2000. Now, there were many companies who bought that data saying that somebody is offering me the database. He is putting it in a CD or something like that. I am paying consideration. I paid 1,000 rupees, 10,000 rupees. Then what is wrong in it? Remember that unauthorizedly acquired data is like stolen data. Okay, we'll use the term stolen data for easy clarity. Now, if I am using stolen data, as a user of stolen data, I am liable under Section 66B of Information Technology Act, which says that anybody who uses a stolen device, computer device, will be liable for 3 years imprisonment. Now, there the word used is device, but the word computer device has got a wide meaning, and I can extend it to the data also. Computer device, computer network, computer resource. and so on. Therefore, use of any data acquired in a manner in which there is no legality could lead to a offense under Information Technology Act. Okay. So when you say publicly made available, one has to be very careful that we cannot say that anything which is available publicly is something which can be scraped. In fact, if there is an LLM which takes data from the Google, then probably they are not legally acquiring it, because Google only gives a search engine saying that information is contained in such and such a place. Okay. So beyond that, Google's responsibility ceases. It doesn't say that you are authorized to use that information. For example, you have seen many images which says subject to copyright. So Google says there is an image like this, but use of it is subject to some other law. So same thing applies here. Something may be publicly available, but not all publicly available data is authorized to be used. Okay. Now, we will use this test on these cases and then see whether we can draw something out of that. Now, the first question, this GDPR compliant, we have already discussed, and unless Ramesh or somebody wants to add anything else, see, GDPR, just because a person is European, it may not automatically come under GDPR, because the processing is related to an activity outside EU. We are talking of the tourist coming here, and then the local tour operator takes care of their personal data. Initially, as I told you, it is a package, 50 persons, this is the charge or something like that. Now, only when local tickets and other things are to be booked, then the question of the name, age, etc. will come. That is when the local operator acquires the personal data of the foreigner. The purpose is to book a ticket for travel, say from Delhi to Ayodhya or something like that. That becomes a local EU activity. So it is not under GDPR, it may come under this. And the local operator need not necessarily be considered as a data controller under GDPR. Okay. But the relationship between the data controller in EU and this person is like a B2B transaction. And that B2B transaction comes under Section 72 capital A of Information Technology Act. Unfortunately, Section 72 capital A talks about personal data, doesn't go into whether it is Indian data, EU data, and other things. It only says that if there is a contract for processing of personal data, and if the processing happens in violation of the contract, then Section 72 capital A may be invoked. Therefore, there is a possibility that Section 72A may come into being. Otherwise, this data is first acquired by the French tourist operator. So if at all there is any need for issuing of any privacy notice, it is for the European data controller to do it, and not the local person. This is my view. You can always contradict me if you don't agree. Okay. Any other thoughts on this? Subraido, you have any thoughts on this? Okay. Now, the second one, I already said that it may not be personal domestic, therefore it may come under the DPDPA. Okay. The third one is more interesting. We are talking of CCTV and this personal visitor management system, which most of the time has got face recognition also. The question which we'll have to check here is, where are the CCTVs placed? Is it in the common area, or whether you consider in front of apartment door as common area or personal area? Say, most of the time CCTVs are put in the corridors and it can watch whoever is going into any particular flat. Okay. Otherwise, what is the use of CCTV? The very purpose for which it is given is that. Okay, that also is a common area, and there are other areas. So now the question is whether this in front of my door, is it my area or somebody else's area? Is it required to take consent of the owners of each flat? These are the issues which societies will have to look at. Then when you have a face recognition, who is managing that face recognition, whether the security company? If so, what is the status of the society? Whether it's a data fiduciary, what is the status of the security company, the face recognition software owning company, visitor management software owning company, who is the data fiduciary, who is the data processor? These are the issues which you need to look at. Is the data put on cloud? If so, what is the role of the cloud storage service provider? Is he a data processor? Is he a data fiduciary? Now, this is a very common service. Okay, and one more thing last. Is there any bylaws in the society? And whether the bylaws of the society need to be amended to be DPDPA compliant. If you consider the society as a data fiduciary, it is collecting the personal data of all the individuals, particularly visitors. It's specifically the name, address, everything is being collected. Then whether it is the data fiduciary or whether the management software is the data fiduciary, still, does the bylaws of the society permit the society to be a data fiduciary? Tomorrow, if there is a violation and Data Protection Board imposes a 1 crore penalty on the society, who will pay that penalty? Will each of the residents contribute to the payment of this penalty, or you will ask the secretary and the president to pay? These are the issues. Yeah, Srinivas, any thoughts on this? You are from Bombay, so a lot of apartments. There are people who are living in various, say, gated communities. Yeah, Rajeshwari wants to say something.
No, sir, they're valid point, sir. So, yeah, this has to be considered, sir.
Okay, so
Sir, this is Radhakrishna. Even if the bylaws of the society are not amended, even then I think this DPDP applies to the society, isn't it?
yes, say you are not amending the bylaws is not a consideration for applicability. Okay,
Exactly.
now
Exactly.
one thing is the DPDPA is applicable irrespective of whether you are a society, whether you are a company, whether you are a government. Okay, there are exemptions for government in some cases. We will see that later on. Okay, and even if it is an individual, because the applicability depends on what data you are processing and why you are processing, not who is processing. Okay,
Yes.
so a society is also coming under the provisions of DPDPA. Okay, so let us say some of you must be secretaries of resident associations. Anybody here?
Yes, Subbarati here. One, I think the notice and consent has to be taken by the society for every visitor who's entering the premises. That is definitely there. And
Okay.
as long as that is done, I think the rest of the things should be okay. As long as, as we say, into the common areas and, we could say that it is a legitimate interest of society to safeguard the safety of the residents. So there can be defended as long as proper notice and consent is taken of the visitors, and that consent is also recorded, so that tomorrow they can be able to prove that it is there.
So consent to be taken by the society from the residents.
Visitors.
That's what you're saying.
Correct.
From the visitors also.
Okay, now personal
Residents.
data is of the visitors of the resident.
Correct.
Do we require a consent from that visitor?
Absolutely.
Yes.
Unless it falls under the exceptions. In DPDP also, the grounds of processing, there are certain grounds where even process without consent can be processed. Okay, for example, emergency, in medical emergencies, public interest and those things, right? Legitimate interest is also there. If it falls under one of those grounds, then perhaps even not taking the consent of the visitors may be justified. But that's what we have to look into.
Okay, we'll come back to that in more detail later on. This is just to trigger some thoughts in your mind. That
Tapasya,
Yeah.
I think the point which you mentioned is regarding law enforcement agency, police wants, that's very valid, because if there is a threat or crime, this data has to be, first thing they look at it is the CCTV footage data, and you are supposed to disclose it to law enforcement agencies. And as a best practice, you should at least keep them for 90 days, should be stored for 90 days minimum.
The law enforcement can process the data under legitimate use. There is no doubt. Now, we are talking of a managing organization, which is a society. It is not law enforcement. Okay. But it is still, you have to see whether the bylaws say that they are responsible for the security of the say residents. Okay. Now let us say it does say that they are responsible for the security of this thing. Then there should be a policy which says, for managing this particular security of the residents, we need to install CCTVs, and then we have to process it in such and such a manner. So then there has to be a CCTV policy. Is that not?
Yes.
The society is a data fiduciary. So it is required to have all the compliance requirements, including reasonable security practices, obligations under DPDPA and so on. One of the things is we will ask, what is your policy before you installed this CCTV? Because CCTV is going to collect personal data. Initially, it will just capture the photograph without the name and address. But when you run facial recognition, or when you link it to the visitors register where it gives the name and address, and then the particular face is linked to that, you are making it an identifiable personal information. So therefore, it comes under the provisions of the DPDPA. Now, is a visitor the responsibility of the flat owner, or is it a responsibility of the society? Is first question. Now, does the society, suppose a flat owner says, whoever comes to my house, why should you know? Now, I'm not saying that you should not do or something like that. I'm only raising these points because in your agreement, that is the for security arrangement agreement with the residents, you may have to ensure that these permissions are taken. The person may come to your house, but he will pass through the common area which belongs to everybody else. Therefore, I have the right to know who is the person and collect his facial recognition, etc. This should be mentioned as a part of the policy. Am I correct?
Yes, sir. Yes, sir. Absolutely.
Okay. So these are the questions. I don't know whether I have got an exhaustive list of what needs to be done, but this is a common thing which every one of us faces. But you see how many DPDPA related issues arise out of that, including the type of data collected, now where do you store that facial recognition, whether facial recognition is a sensitive personal information, because today Aadhaar is going to introduce facial recognition, authentication and others. There could be an Aadhaar authentication linked to a financial system. So if you capture my face here, I don't know whether your system can record it and use it in a banking transaction. So these are the risks actually. When you make a risk register, you have to look at all these registers for the society. So a society which is having so many people visiting, you have as much complications as a corporate entity. Arvind?
Yes, sir. So this, with respect to the criminal penalty or the imprisonment, how does a person or probably a DPO would be responsible for the negligence arising from the past or the retrospective actions that would have taken from someone else? And then just because we want to set an accountability on behalf of organization, are we making DPOs like a scapegoat, sir?
No, DPDPA does not deal with criminal punishments directly. Okay, let us be frank about it. It's only the penalties which it prescribes. The ITA 2000 has got criminal offenses. Okay. Criminal penalty can come only when there is a damage which has occurred to a particular person. So it is the cause should be there. Okay. Now, if somebody can prove that I have suffered a criminal damage, therefore I want somebody to be criminally liable, I don't know who is the person. Okay. Now, there is in section 43 of Information Technology Act. See, even when I refer to this, you can also see there is a website ita2000.in, which is my own site, or a link from navi.org is there. You can refer to the Act. So, Information Technology Act has certain provisions which state that if an offense is committed by an organization, it is relatable to an individual. Okay. Then under section 43, there is one subsection. If I remember, it's 43 subsection G, which says that if somebody assists another person to contravene the act, then the person who is assisting is also responsible. Okay. This particular question came up in the Umar Shankar versus ICICI Bank case in the TD SAT, where we argued that the bank had not followed the Reserve Bank guidelines on security. There was negligence. This negligence in security caused the criminal to say withdraw the money or something like that. So there was a consequential contribution from the ICICI Bank. Okay. And that was part of the judgment of the TD SAT. They agreed that there is a 43 subsection G violation by ICICI Bank for not following reasonable security practice. So similarly, if a DPO is held responsible for certain compliance, including reasonable security, there could be a possibility under ITA 2000. Okay. Then there is something called breach of trust, which also comes under IPC kind of a thing. So those are the instances where DPO can become criminally liable, but criminal liability will only come when there is a malicious intention. Okay. And mens rea. If it has to be applied in a civil context, there has to be a recklessness or gross negligence. Yet, if you are doing something in good faith and things go wrong, you will not be called upon to be criminally liable. Okay. But you may still be liable for the civil damages. Okay. You may still be asked to pay penalty, though you may not be put in jail. Okay. The imprisonment and criminal liabilities will come when in a particular context, you are found to be grossly negligent or reckless. For example, in a driving scenario, if there's a drunken driver who commits an accident, he has got a possibility of being held for that negligence beyond a particular level. But if you are in good faith driving and suddenly somebody else comes in front of you and an accident happens, even though the consequences may be same, okay, you may still be considered as not having any criminal intention or gross negligence which resulted in the particular fatal accident. So similarly, here also the DPO may not normally be exposed to criminal offense. I just made a mention of it because under the Information Technology Act, when you invoke section 43, automatically section 66 gets invoked, which is a 3-year imprisonment section. So one has to be very careful. That is, if there is a data breach which causes certain damage to an individual and he claims compensation under section 43 and he's held, the organization is held liable, the next question which may come is whether the negligence was simple negligence or gross negligence. If it is held as gross negligence, there is a possibility of criminal action I'm just pointing out to that as a risk. Okay. So DPO, if he is considered as the person who is responsible for the security in a particular context, he also may face that question. If nothing else, he has to face that charge. Like what this Bazi.com executives faced for 8 years, they also will have to be answerable to the court and prove that what they did was in good faith. They did not have any malicious intention. Things still went wrong for certain reasons. Therefore, they should not be held criminally liable. So that is something which you need to.
Just one question.
Yeah. Yeah.
It's interesting when you're using the word facial recognition. Every CCTV camera might not be capable of facial recognition. If it is just mere recording and it needs human viewing to recognize who that individual is, then it is not necessarily facial recognition, just plain CCTV recording footage, that's all. Whereas if it could be certain AI-enabled cameras which are also recognizing faces, then that's a different league altogether. So if it is a plain CCTV camera not capable of facial recognition, does it make it that the data PII?
Well, you are perfectly right. Say, mere taking of a photograph does not identify the person unless at the back end you are running a facial recognition software and then matching it with some database, etc. Okay. Now, these two are different operations. Capturing of the image is one operation. Then identifying the face with somebody is another operation. I say that the second operation is the one where this risk of privacy violation is there. See, the whole, and then there is a storage. Then whether the storage itself is encrypted, all this, so the CCTV camera work, it has got multiple processes. At a later time, we will be discussing in the DGPSI the need to have a process-based approach to compliance. Here, we are already recognizing multiple processes. That is capturing of CCTV, and that will be under the control of that particular say security guard or somebody like that who can switch on and switch off the CCTV. So capturing is his responsibility. Now, once it goes into the server, he may not have even access to the server. Okay. Then there is somebody who is running the facial recognition software, which is stored or which is an application which is running elsewhere. Maybe one person is authorized to run that facial recognition software. Now, what I mentioned in the case is the facial recognition is only to monitor the movement of the face within this premises. At that time, you are identifying the face for face, but not still identifying who is that person. Okay. Only when he does a suspicious activity, then the question will come, who is the person who did this? And then you run the facial recognition software. That's a different process. So that is why you have to build the operation and break it up into multiple processes and look at compliance in process 1, process 2, process 3, all put together maybe one bigger activity. Okay. So what you said is correct, that capturing of the image itself may not lead to identity. It is like collecting the IP address on a website. Okay. Say IP address is not identity. It is one of the parameters. Only when that IP address is connected with something else, it becomes identity. Same way, CCTV camera picture is not the identity. When it is run with the facial recognition software, it becomes an identity. And the person who is doing that, he should have specific authority to run the facial recognition software, and justification for that, maybe documentation why he is running the facial recognition. Okay, it is same thing when a law enforcement officer comes to you and asks for the footage. Okay, he will go back and run that facial recognition software as a different process. So if you break it up into that, you will see that different people have got different responsibilities. Okay.
Yes, sir.
Sir, I have one question.
Yeah.
See, usually in our officers, we also implement CCTVs. So let's say the person who is monitoring the CCTV, let's say a security guard, if he captures the photo on his mobile from the CCTV, who will be responsible? Will the DPO be responsible, or will the security guard will be responsible in this case?
Do you have a policy that it should not be captured? And have you communicated that policy to this particular person? These are the issues which you have to take into account.
Okay, okay.
So it is the same case when a company has got a remote access kind of a network where you are logging into your client's network and processing data, and you can still take a picture of your screen. Okay. So you have to have controls for that. The control starts with having a policy, communicating that policy to the concerned person. Then if he violates, then you can ask him the question why you violated this. But if the security company is sending some ad hoc persons, one person today, one person tomorrow, then you should have control on who is assigned the job as of today, whether they can switch people without your consent. Say they should have a battery of, say, 10 people assigned to your company, let us say. You may require only 3 people, but they should get approval for 10 people, and then within that 10 people, they will have to allocate, so that you could have conducted a training for all the 10 people and told them what is their responsibilities.
Oh, got it. Got it.
Okay. Yeah. Anything else?
Sir, this is Rajkumar. Again, going back to the residential CCTV without the facial recognition. So one side, as you said, it just captures the movement of an individual, whether it is residents or guests or vendors, whomsoever. So it is the individuals is how we take. But on the other side, there are the in-out, the entry, exit companies like Adda or MyGate who manages the collection of personal data when a visitor comes or a vendor comes, and they take a picture of who comes and their personal data. So do we need to see these two, the CCTV as well as the data that is stored in this Adda or MyGate or any other kind of an application in conjunction to consider that as a personal data? That is how we need to look into it, sir.
Yes, say there are data elements, personal data elements, and a personal data. Say a personal data element, when it is combined with other elements, it will become personal data. In fact, when we tomorrow come to the discussions of later on next week, when we come to the discussion of the classification of creating an inventory of personal data, this is what you have to think of. That is, we collect data elements at different points of time. And then when we integrate some of these things, then the identity emerges. Likewise here, a CCTV footage itself is not giving the identity of a person, okay? But when you have a list of visitors whose name and other things are there, there is the database, and then you link this there, then that list along with this CCTV footage becomes a more sensitive personal information. The list itself is personal information. When you add face, it will be more. And then suppose the police take this and then make a search of this face in the railway station, they are actually expanding the search into a bigger database, for which of course they may have their permissions, but you don't have that permission. Okay, you as a society owner may not have that permission. So within your perimeter of say control, you can use that, but you have to have a policy for that. You have to authorize somebody. See, the security guard did not know the name and address of the persons fully. Okay, that is, the gate person will make the list. Then this person goes inside. There is another security guard somewhere else. He may or may not know the name of this person. Is it not? He only looks at the person, and then if he's doing any suspicious activity, then he will ask what is his name and other things. If necessary, he will refer to the database or at the gate. Okay, so you must be able to segregate the activity into sub-processes and identify people who are responsible for data management in each of the sub-processes. Are you getting this point?
Yeah. The data that we collect needs to be used only for legitimate purposes is what it really boils down to, right? I mean,
Yes.
we shouldn't.
The gate person will record. Okay, then he will refer to the flat owner, gets his consent, he will open the gate. His purpose is over. Am I correct?
That's right, sir.
Then there is another person who is, let us say, near the flat or something like that. His purpose is to watch people moving around, whether they are simply walking like a gentleman into the flat or they are doing something mischievous. So his objective is different. Now, he will not go and ask every person what is your name and address. But if he sees somebody who is doing something suspicious, then he will either ask him or suppose another CCTV has captured some mischievous activity, then they will refer to the name and address of the person. So this identification following an incident is different from the entry point processing of personal information.
Makes sense, sir. Thanks.
Okay. Okay. So we are taking a very simple example, but if you go deep into it, the complexities will be there. The same complexities you will see in the industry situation. Also, where perhaps you will be able to appreciate the risks much better. Okay.
So, Navi sir, sorry, in a nutshell, then we can take it that all the accountability and responsibilities needs to be clearly laid out or specified in the bylaws of the society. Am I right?
Correct. Correct. See, you will do it in the corporate environment, but today we are asking the question, are you doing it in the flat in which you are there? You are not the CISO there, but you are the person who knows this. In your society meeting, have you raised this issue? Because the current society secretary may be an old person who doesn't know about cybersecurity. Am I correct?
Yes, sir, absolutely.
But the risks are there. And tomorrow, say there are flats which have got 1,000 flats, 2,000 flats in one cluster. Okay. And there are 10,000 people there. It is not a small entity. So there is a need for that society to be DPDPA compliant. Okay. Which is much bigger than an SME. Okay. In SME may have only 10 people. Okay. Whereas here, there may not be revenue turnover, but there are 10,000 people whose personal data which is being managed, and that too sensitive personal data. Tomorrow, when it comes to deciding who is a significant data fiduciary. Now, this is a decision which the data fiduciary has to do on a self-evaluation basis. Okay, MIT has said that you have to decide whether you are a significant data fiduciary or not. They have only given the criteria in the law, which says that the criteria will depend upon the volume and sensitivity and the likelihood of harm caused to a data principal. Now, there could be a murder happening in a flat and apartment. So if you allow an unknown person walk into it, the harm could be even causing death. So it is not something which is simple. So when you do a risk analysis and then put that risk, if I ask you to put sensitivity of the risk, I will say, have you taken the possibility that the person who is entering without proper identification can kill a person inside this thing? If it is so, the harm is limitless. So should it not be considered as a significant data fiduciary? That is the question. Okay. To be a significant data fiduciary, it is not necessary that you should have 10 million, 20 million data only. Even if the number of data processed is small, if it is sensitive, like a laboratory which is having a DNA examination or something like that, okay, then is it not as SDF, the significant data fiduciary? You are having a medical laboratory where, say, some cancer detection is done. And so there is highly sensitive information which is being processed. And even though the number of such cases are less, say 100 per month or something like that, that organization needs to be considered as a significant data fiduciary. So let us not think that significant data fiduciaries are only Twitters and Meta or something like that. They are so because of the volume. There are many other instances where volume is not high, but sensitivity could be high. Take an example of a company which is actually supplying defense equipments. Okay, with critical defense material. Then that company's CCTV footage, who walks in, who walks out, it is significant data fiduciary activity because this company is handling some activities which are critical to the national security. So you have to look at all these things when you actually create a sensitivity, let us say, score for the data. That will determine the significant data fiduciary status, which is almost the first thing to decide whether I need a DPO in my organization or not. So once you identify the data which you are processing, then you have to look at the sensitivity of the data, the volume of the data, whether the data is related to national security, whether the data is related to electoral democracy, whether it will have a harmful effect on the data principle, and then decide, should I be considering myself as a significant data fiduciary? So there are now, according to the rules, the ministry is going to set up one officer or somebody like that. And they say that he will from time to time come up with the details of what class of data fiduciaries are to be treated as significant data fiduciaries. But I don't know whether they will come up with a specific list or leave it as a enabling provision. But the decision whether I'm a significant data fiduciary or not should be taken by the data fiduciary himself. But tomorrow, if something goes wrong, the DPB may come and ask, from your activity, you should have considered yourself as a significant data fiduciary. You were negligent in, first of all, classifying yourself as not a significant data fiduciary. Therefore, you did not have a DPO. Therefore, you did not have a data auditor, etc. So this is a big responsibility on every data fiduciary as of now. Okay, some of the other small questions which I put for the discussion is, now one, if metadata is not identifiable with the data principle, like the IP address on a website, should it be considered as the DPDPA protected data? This is a question you can think about it. Now, you have got two emails, navi9@gmail.com, navi@ujjwala.com. Is it a personal data element or is it a business contact data? These are all issues which we sometimes make mistakes. Your system, you might have configured that if I say @gmail.com, you will not consider it as a corporate data and you will refuse certain services. Okay, say that you want business data, business contact data. But if I say ujjwala.com without knowing what is ujjwala.com's activity, you will accept it as a business data. Whether that is the correct approach, or every time you collect an email address, you ask the person, is it your personal data or is it your business contact data? See, it is my decision to use navi9@gmail.com for business. So when you ask a business data, I may give you navi9@gmail.com. What right you have to say that, no, I will not accept it. You give me some other domain. Okay. If I say navi@navi.org, you will accept it. But navi.org may be more personal than what I'm doing under the gmail.com. Okay. So this is again a GDPR based concept because others are using this. You are considering that anything which comes from Gmail is personal data. Anything which comes from other domains is not personal data. But actually, you have to ask the person in the data which you are collecting. If there is an email field, you should ask business email. So if I say navi9@gmail.com and enter it under business email, please take it as my choice that should be considered as business email. It should be accepted as a business email for whatever purposes. Okay. Then proprietor or partner. Now, suppose there is an activity of this partnership firm, like a business lunch, hosted by Mr. So-and-so proprietor, then is it personal data? Is business data? Again, it depends on the same context that it is the right of choice of an individual to actually determine what is personal, what is business. Okay. Now, there are instances like this. A person sends an email from one IP address. You receive it. But when you look at the originating IP address, that shows Google's proxy address. Is it because Google is trying to have privacy protection? Is it sustainable as a privacy protection so that you are denied the knowledge of where from you are getting an email? Same way, domain name registrars are doing the same mistake, that when you ask for who is information of a registrar, registrant, they say that no, it is privacy protected. Unless you come with a police notification, CRPC notice, I will not give you the information. By that, they are denying many times an opportunity to a person to file a complaint or whatever is that. They are also trying to defend it under the guise of privacy. But actually, there is no privacy here. There is no privacy here. Okay. Google is not understanding the privacy concept. If you are sending an email to me, then I have the right to ask from which IP address you are sending it. Google cannot say that I will not tell you, it is privacy protected for you. There is no right given to a person to actually shoot from darkness. He has to come to the open and say, I am so and so, and I am sending the email. Okay, so these are some of the issues which the community has not taken a view. Maybe we will be discussing it for some time, and if you are trying to use that concepts, then you have to have policy documentation to sustain your interpretation. Okay. Right. Now, shall we close this for today and continue tomorrow? Any questions? We'll take another few minutes for answering any questions. We have only discussed on the applicability issue, and to some extent, we have discussed other aspects. Yeah.
Just put a question in chat. Can you just answer that?
Yeah.
I have put the question in chat.
Okay. As per certain laws of ICT are mandatory for 100 days. ICT, okay. Say now, as far as data retention is concerned, okay, DPDPA says that basically data has to be collected and retained based on the purpose. But if there is any other law which requires data to be retained for a different period, then you can retain it according to that process, that law. Which means that in your policy, you please mention that as per Information Technology Act, this data is being retained for so many days. But when it is beyond the purpose requirement, it is a legal requirement. Then you have to shift the data from production storage to archived storage, maybe with additional security like encryption, because that is kept there only because there is a legal requirement, only because there may be a demand for that information from law enforcement on a particular day. At that time, you have to pick it up and give it. It is not required for your normal operations. So data has to be moved from the purpose-based storage house to the archival storage. Okay. It is not only 180 days. There may be instances where you may have to keep it for 5 years, both under Information Technology Act. Maybe if it's a financial data, if it's a health data of a hospital, you may be keeping it for several more years. Okay, there may be other laws also which will require you to keep it. So there is a possibility that retention may go much beyond the purpose. But for DPDPA compliance, try to put a cutoff on purpose-based storage And then you say it will be moved to archive. There will be a separate person who is responsible for the archival, a senior security person, and maybe it is encrypted and kept there so that the risk of any damage to the data is reduced. Don't keep it in the same server where you are. HR data is also like that. You keep it until the person actually retires. Okay. So obviously for 30 years, you don't have to keep it in the same production server, no. Say if last year's transactions are there, salary and other things, at least if you don't require it after the tax filing and other things, move it into a different storage so that you will be able to change the risk profile of the data. Does it answer your question partially?
So not partially, perfectly. Thanks a lot.
Okay. Yeah. Any other questions? Yeah. Ramesh, you want to add anything? Manju, you have anything to add?
I have a small organization.
Yeah.
And I collect the visitors' data in a physical format, in a notebook.
Yeah.
Later, I convert them into digital format. So the act applies for them. But
Yes.
somebody steals my notebook, not my digital data. So
Yeah.
what?
You file it under the theft under IPC.
That is what whether DPDP or appeals to.
But let us take another example. Okay.
Sir.
You are
Okay.
an examination manager or something like that. Okay.
Okay.
You have
Okay.
collected certain OCR sheets,
Sure,
either
sure.
answer sheets or application. Okay.
Okay.
Now somebody steals that. Okay. Now the question is whether that OCR sheet is an electronic data or a paper data. If the data is meant to be read by a computer, because you
Yes,
can't read the OCR data, humans don't make much out of that. Okay.
Yes, sir.
But computer, when you put it, it will recognize something more. It will read meaning into it. No? So
Yes.
a document, a paper document, which is meant to be processed in a computer or is being processed in a computer or has been processed in a computer is considered as electronic document under Information Technology Act. So therefore, if it was not a simple notebook, but a kind of preparatory document for being put into the computer, like you have put boxes, say most of the bank application forms, name,
Yes.
you will
Yes.
put one box. Why are you putting one box? So you want to help the data operator to consider each as a particular element, is it not? So
Yes,
I can argue that this form is not meant to be simply used and thrown as a paper document. It is meant to be processed in an electronic document. So I will invoke Information Technology Act to prove that this is not a paper document, this is an electronic document. If it is an electronic document, then DPDPA becomes applicable even for that. Are you getting the logic?
Yes, yes, sir. Yes, sir. Thank you. Thank you, sir.
Yeah. Okay. For the first day, I think this is sufficient.